Good morning, afternoon, or evening. Welcome to Law Kept Simple. I am Stephanie Joy, sharing with you a little legal concept or legal definition, whatever else comes across the plate that some people are asking, what does that mean? Without having to do all the legal research themselves. It is simple, it is to the point. It doesn't make you a legal scholar, but it might just give you a understanding of the legal concept. So if you're in a conversation with somebody and don't want to look utterly foolish, you might have a little bit of knowledge in a very few minutes of time. Thank you so much. Have a great day. Oh, okay. Hi, Quinn. Thanks. Yeah, you threw this one at me kind of last minute. It's fun though, because this is one of my favorite areas back in the Stone Age when I was in law school. One of my best classes was evidence class, and hearsay was seriously so much fun. And what was particularly fun about it to me was that so many people didn't get it. So many law students, now lawyers, did not get what I thought to be a really terrific kind of logical scenario when you're trying to figure out if something's hearsay or not. People had such trouble with it. And to me, it was really, really basic. And believe it or not, I think it goes back to certain math capacities. I know that sounds strange, but maybe even tautologies. But because I actually used to picture the problem solving of a hearsay question, and I'll tell you why hearsay is so important when we're talking about evidence and whether something's going to get into court or not to prove something. I know that's all, kind of big right now on the national stage. So it was interesting to me because I would lay it out like a diagram, almost as if I was doing I want to say an algebraic expression with parentheses and parentheses within parentheses. And that's averring to hearsay within hearsay, which could really wrap people's minds up, but I loved it. Anyway, it was one of my top grades in law school. Okay, so hearsay, people get frustrated, if a witness goes on the stand. So this is really basically in pretty much every jurisdiction in the United States, hearsay is generally not admissible evidence. So you can't admit generally a piece of paper with a writing on it if you are bringing in that piece of paper with the writing on it to prove the truth of what that writing says. So hearsay is basically an out-of-court statement. It was not made on the stand, brought in by its proponent to prove the truthfulness of what that statement says. So if something is brought in not to prove the truthfulness of the statement itself, but to prove something else, then it wouldn't even be hearsay at all, and therefore it wouldn't be barred under the hearsay rule. Now, in addition to potentially not being hearsay at all, some statements that are hearsay have an exception to them. This could be a dying declaration is always the famous one. If someone says something on their deathbed, it loses I suppose because it is expected to be more reliable than any other out-of-court statement, generally, that it can be allowed in. There's a ton of other exceptions, record keeping, certain record keepings are admitted. And the point is that you don't have to bring in the original speaker of the statement to be on the stand when it's an exception to hearsay, which normally you can't, like saying you can't have a hearsay statement brought in, you have to have the actual person who's saying it. This could be, say, medical records. The substance of medical records may not be admissible because it's hearsay. However, and this is why in a lot of cases, you have to pay the doctor to come in and testify as to perhaps what he recorded, what does he think now? And that's why certain litigation in medicine, involving medicine, personal injury, medical malpractice is so expensive because you have to bring that doctor in to testify as to his treatment and everything because the records are hearsay. So it's frustrating to people who don't understand why the hearsay rules exist. And it is simply because there is no way to know if what the person now testifying to what was said before outside of court, could be 10 years ago, what they're talking about, did they interpret it properly? Can we ask the person who actually said it? The reliability of the portrayal of that long ago statement is really, really so unreliable. We have people, aside from the fact that firsthand witnesses tend to be very unreliable pieces of testimony, and they get shot down all the time. Perception, it's not even a credibility thing. It's not necessarily even about someone's lying. It's the reliability of their perception, their memory, their recollection, their interpretation. Think about all the things. Think about social media and how people are constantly getting offended at other people who don't necessarily mean offense. Sometimes we do mean to be offensive, but sometimes you're just saying something factually and suddenly, the person saying it can be accused of all sorts of things, racism and this and that. It's like, what? So the other people's ability to perceive is so warped at times, and it could be their worldview. It could be their biases, whatever the reason. So the goal is to always have the actual person with the firsthand knowledge of what is being said there on the stand. But that's not always possible. And that's why there are exceptions to the hearsay rule when there is indication that the statement is less unreliable than typical. And like I was saying, that dying declaration, there's excited utterances when you're saying something in the heat of an event or immediately thereafter. It could be a really bad car accident and someone says something that might be able to be brought in. Whoever heard it can testify as to what they heard. It was, say, someone that's involved in the car accident saying, "Oh my gosh, I didn't see that stop sign till after." Right? So that might be able to be brought in because it is an excited utterance and it's certainly against their own interest. But and it doesn't mean that because it's brought in, it has to be believed by the jury. And I think the fact that there is a jury, by the way, is a large reason why hearsay is kept out, because it can be so prejudicial. Sometimes jury members are just really easily impressionable and believe anything they hear, and they don't have the benefit of understanding, maybe whether they're being played or not. And I know it sounds like insulting to jurors, but it's true. And it's why certain areas of law where there's a jury, it is a talented litigators are really skilled in drama and theatrics because they are being persuasive of a jury, not a judge who has the forethought of knowing what they're, who's on what side and what the games are to be played. So bench trial versus jury trial, but the rules definitely apply in those venues regardless. So even a judge, a bench trial, he's not going to be able to listen to hearsay or allow it in. Someone might object and say, "Judge, that's hearsay. They can't let that in." And then the other side might say, no, there's an exception to the hearsay rule. It's this. Or they will say, "No, I'm not bringing in this in to prove the truthfulness of the statement itself, Judge. I'm bringing it in to show something else." And then he will say, "Okay, so proffer what you're showing there." And I'll give you an example. What wouldn't be hearsay then? Let's say someone's going to testify that Johnny said, "Oh my God, it's raining outside." And someone says, "They can't say that. It's hearsay. He was saying it last week or whatever." And the proponent says, "No, I'm not bringing it in to show that it was actually raining outside. I'm bringing it in to showing that Johnny, who you claim had laryngitis and couldn't talk that day, and that's why he wasn't at that meeting, actually didn't have laryngitis because Betsy here is testifying that she heard him talk about the rain that day." You follow what I'm saying? So it's not actually about the rain. It's about the fact that he could speak, the action. So the statement isn't really about the contents of the statement. It's about the act of speaking in that particular instance. Hearsay, so much fun. Then the other conundrum would be, and there's so much more to this, but I'm giving you guys just the nutshell. That was all I was asked to do, explain about this whole hearsay dilemma. Hearsay within hearsay. This is where I was getting to the parentheses within parentheses when you're looking at equations of some kind, which being a math person back in the day, I loved this stuff. So when evidence class came up, I was like, "Oh, this is great," because the majority of it seemed like my classmates really struggled with it. And my mind just works a little differently. And I kind of put things into numbers and equations, and then the right answer would invariably result. So I could put it into a mathematical formula and then it would result. So hearsay within hearsay is when, so you have the person that's testifying, what they are saying, they are not themselves, their statement is not hearsay, but the statement that they're talking about that someone else said is hearsay. That's the original hearsay, right? Like when Susie's saying that Johnny said, "Look, it's raining outside." That's regular hearsay. Then if Susie said, "Well, I heard Johnny talk about how Wayne had called from the other room and said that it was raining outside." So Betsy, did I say Betsy? Betsy, who's testifying on the stand, is saying that Johnny was talking about how Wayne was saying it was raining outside. Hearsay within hearsay. What Johnny said is hearsay, and he's speaking about hearsay within that. I was trying to think if there was an example. There's a website called rulesofevidence.org, and they're going over Rule 805, which is the federal rules of evidence number for hearsay within hearsay. And it says, definition: hearsay within hearsay, or double hearsay, as they call it, occurs when a statement contains another statement and both are offered as evidence. For example, if a witness testifies about what someone else said and that person was quoting a third party, both layers of statements are considered hearsay. So the way I would do is I would always say what is being stated by the person that's speaking now. Say it was on the stand. But you can do this even when you're going through articles. It's a great way to parse out what's hearsay, what's not, And you could always do more research to see if, because from our point of view, we're not really subject to the rules of evidence unless we're talking about, is this going to be going to trial and will this be a piece of evidence they can use? So, I would be putting things in, here's the big picture of what he's saying. And then here's the part that Johnny's saying. And then here's the part that Wayne is saying, which is within the part that Johnny's saying. So hearsay within hearsay. Super fun, little brain teasers at times. So again, and when it's hearsay within hearsay, if both pieces can be subject to one of the many, many exceptions of the hearsay rules, the hearsay exception rules, then that whole double hearsay can come in. One of the things about, and just to drive it home, it's hearsay when the person who's saying it cannot be brought in to be cross-examined about what he said. That out-of-court statement. So let's say there's an out-of-court statement by Wayne, and Wayne can't be brought in to cross-examine him about that. What joke when you said that? Or what about, what if he can't be brought in to cross-examine? That's why it's unfair, because everyone's supposed to be cross-examined by their accusers, which would also include, in a way, witness statements. Even if they're not present, you can't cross-examine them. And that is probably the biggest reason why hearsay as a general rule is not allowed. And therefore you have to look at all those exceptions that we were talking about. I want to see if the exceptions are under Rule 803, by the way, in the Federal Rules of Evidence. And most states have adopted the Federal Rules of Evidence in some way, shape, or form, I believe. There is a list here. This is at Cornell Law School. I mean, I'm looking at 23 right now. And they start with some of the real obvious ones that we're always talking about. Present sense and impression, which is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. That is not exactly the same as an excited utterance, but it's not far off. So if Betsy is testifying as to something Johnny said, and when Johnny said it, at the time he said it, he was describing or explaining an event or condition, and the statement that he made was while it was happening or immediately after he perceived it happening, then Betsy might be able to testify as to that, as to what Johnny said. Now, keep in mind, too, it doesn't mean you have to believe the statement to be true. It's just that it's admitted. That doesn't mean it's got a lot of weight. It doesn't mean there's going to be, like in any case, there's always going to be the alternative is being said by some other witness. So just because something is admissible does not mean it's of high value. It just got over that minimal bar of not being completely unable to be vetted in any way, shape, or form, and is full-blown hearsay. Another one that they give an example of is excited utterance. This is what I alluded to before. A statement relating to, did you guys just ask me to, did someone just ask a question? Oh, all right. Nope, I'll continue. Excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. And honestly, that just seems part of present sense impression to me, but it's a carve out maybe because I think the reason is that when someone is saying something in the heat of an excitement, they're not usually making anything up. They're not necessarily in hyperbole or satire, right? It's usually like off the cuff, just out the mouth, no filter. And it's funny, we're always talking about everyone should have their filter and, blah, blah. We make fun when someone doesn't have the filter. The people that don't have the filter are usually being the most honest. And that is why when these excited utterances happen, no one's using a filter flying out of the mouth in the heat of some excited situation. And that's why it's more credible. So when you see people make fun of people who have no filter, it might just be because they're telling the truth. And nobody wants to admit the truth sometimes. Then there's one called the then existing mental, emotional, or physical condition. I'm not going to go into that one only because it would be a little complicated for this short little ditty I'm sharing with you. Statement made for medical diagnosis or treatment. Same. I'm going to pass on that. Recorded recollection. This one is always good. A record that A is on a matter the witness once knew about, but now cannot recall well enough to testify fully and accurately without that recorded recollection in front of them, which they want to admit. B, was made or adopted by the witness when the matter was fresh in the witness's memory. And C, it accurately reflects the witness's knowledge. If that is admitted, that recorded recollection, the record may be read into evidence, but may be received as an exhibit only if offered by an adverse party. So the person wanting to get it in can have it read into evidence, but they can't submit it for the jury to then go and read over and look at and finger and all that stuff. It's only read into the evidence, read in court, and therefore becomes part of the evidence. But the opposing party could bring it in if they have a reason to. They can, if they are the one that's trying to bring it in, they can get in the physical recording that the other side has read in. This is really useful a lot. Records of a regularly conducted activity. A record of an act, event, condition, opinion, or diagnosis can come in as an exception to hearsay, because remember, the record is already done, right? In a business, someplace, blah, 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 and you want to bring in that record to show something. That can happen if these things. The record was made at or near the time by or from information transmitted by someone with knowledge. B, the record was kept in the course of a regularly conducted activity of business, organization, occupation, or calling, whether or not it was for profit. So it's just kind of like the normal business records. C, making the record was a regular practice of that activity. And D, all these conditions are shown by testimony of the custodian or another qualified witness, or by a certification that complies with a particular other rule, which is 902, 11, or 12, or with a statute permitting certification. And E, the opponent does not show that the source of information or the method or circumstances of preparation indicate a lack of trustworthiness. So those are really important. That could be when you can get in phone records, because those are regularly kept by a phone company, blah, blah, blah. You're probably going to want to get that certification statement from the phone company conforming with Rule 902, so that you don't have to bring in the custodian. What are you going to do? Pay some lady that works out of 10 states away because she's the custodian of records? But that's how you can get in those kind of things. Like you need to prove that someone called you. You know, someone said, I never called her and threatened her. Well, how do you prove that he did or that he didn't? Well, how about the phone records? And if there's a phone call from his number to her number, bingo, doesn't prove he threatened her, but now he already lied that he never even called her. And now you proved that he might lack credibility, which can help you prove that what she said about the threat may be more apt to be true. So it's all those kind of things. The same is true of an absence of a record of a regularly conducted activity. This I find even better. And one thing we used to focus on back in the litigation days, and I still actually focus on it now just because of the work I do with Social Security disability, what isn't said versus what is said. Evidence that a matter is not included in a record described in the above paragraph I just mentioned about records in the regular course of business, if the evidence is admitted to prove that the matter did not occur or exist. B, a record was regularly kept for a matter of that kind. And C, the opponent does not show that the possible source of information or other circumstance indicate that that record would lack trustworthiness. So going back to it, that is super, super important. So let's say you're the guy, the defendant, and the girl is saying, and I'm using genders, you can mix these up, guys. I don't mean to be sexist. You know me, Quinn. So if the girl, we're just going to use the girl, she says, he called me and he threatened me on my phone. Her records are subpoenaed by the other side, her phone records, and there is no call to her at all that day when she said it happened, and none from his phone number in months and months. Her credibility about him calling her because she said he called him at this phone number is going to take a serious potential hit, because this evidence is probably going to be able to get in. Doing it the right way, getting that certification. This is the phone records from that month from AT&T, and there is no call to your phone that entire day, and there's no call from his number. And you said it was him, you saw his number or whatever the facts lay out, you can use that lack of why it would be in here, wouldn't it? The absence of a record. There is no record of that phone call in what would normally be a very thorough and reliable document showing all incoming calls. So I love that one personally. Always looking for, well, what isn't showing up that would show up if what that person said is true? This brings me back to what I'm always babbling about, Quinn, about circumstantial evidence. What would be showing up if the scenario laid out the way that person said? What circumstances would naturally exist if that was true? And were they, or were they not? And then getting that evidence, because that can really nick away at someone's credibility. It works so well. I really am pretty much a proponent that circumstantial evidence is probably more often stronger and will win more cases than even purported direct evidence. Of course, direct evidence is really the kind that people hide as much as they can, and it's not to be found, and therefore, you have to sometimes rely on circumstantial. Number 8 is public records. It's a record or statement out of a public office if it meets certain criteria that's noted. Public records of vital statistics, which would be number 9, which is a record of birth, death, or marriage if reported to a public office in accordance with a legal duty. And then, of course, there's the absence of a public record, which I'm not going to repeat, but it's all about the same kind of idea of what I was mentioning before. Records of religious organizations concerning personal or family history. This is number 11. This says a statement of birth, legitimacy, ancestry, marriage, divorce, death, relationship by blood or marriage, or similar facts of personal or family history contained in a regularly kept record of a religious organization. That has long since been, and I know even in my field with Social Security disability, those documents can be used to prove parentage, for instance. Yeah, that's getting a little bright. Sorry, guys. Parentage, I'm rolling, and things of that nature that come down through a religious organization. And this is particularly important back in the day when there was some, back in the day, there was no vital statistics maybe readily available, small towns, people weren't born in hospitals that have their requirements for recording these things. So that is where, those things became very, very important. They were probably the most relied upon thing for items of that nature. Certificates of marriage, baptism, and similar ceremonies. They go into details about that. Number 13, family records. Those can also be exception to hearsay. But again, those tend to have that longevity. They're not usually made yesterday. So that's what gave them, they've been handed down, passed down. It's an old writing, and therefore it's considered to have a little bit more reliability. Number 14, records of documents that affect an interest in property. We're going to talk probably real estate. I will pass on any details on that because that's not fun. 15, statements in documents that affect an interest in property. I will pass on that. This one's always fun. Statements in ancient documents. The reason why I think this is fun because of what they say here. This has been updated since I graduated. Number 16, statement in a document. This is called statements in ancient documents, mind you. A statement in a document that was prepared before January 1st, 1998, and whose authenticity is established. 1998 is now considered ancient. What does that make me? Mummified, I suppose? And all of you, actually, you guys are about my age, some older, some younger, but not by much, right? We're all kind of up there. 18, statements in learned treatises, periodicals, or pamphlets. That's always interesting to me. Learned treatises, periodicals, pamphlets. I always think, well, what about the fact that people say that history has been rewritten? Should we be trusting certain, I just throw the question out there. This one's interesting. 19, reputation concerning personal or family history. A reputation among a person's family by blood, adoption, or marriage, or among a person's associates or in the community concerning the person's birth, adoption, legitimacy, ancestry, marriage, divorce, death, relationship by blood, adoption, or marriage, or similar facts of personal or family history. So I suppose if there is no other better source of evidence, and because separately we also have the best evidence rule preference, if there is no other evidence about an adoption or a marriage that they get, but the reputation has always been they were married, or yeah, he was born to those parents, or family by blood, for example, that they mentioned, the reputation can actually be introduced, like what the general people in the area believe to be so due to the reputation. Now, again, that's not going to be conclusive, and it doesn't go to the weight of the evidence. It just can be testified to. Doesn't mean anybody in the jury or the judge has to believe it. It just means it can get in before them. So always remember that. It's not about once it's in, it's gospel. Not true at all. If that was true, we really wouldn't need jury trials, right? No one to evaluate the strength of the evidence or the persuasiveness. 20, reputation concerning boundaries or general history. That was boundaries of land in the community. All right. So I suppose that would be property rights in a sense. I'm going to move on, though, because we're not going to get into the weeds. Reputation concerning character. This is number 21. A reputation among a person's associates or in the community concerning a person's character. I'm always telling my kids, particularly if I think it's foreseeable that they might be involved in something that's hurtful or hurt their feelings, or, let's say it's a breakup or something, with their tender little hearts, these young people, right? And I always say, listen, don't know what's going to happen, but if you're worried about it, and I just had this conversation not that long ago. And I said, just remember, no matter what happens, you act with dignity, you act with character. You do not attack the other person who you're very hurt by. You act like a gentleman or a lady, and you wish them well, and you do not talk bad about them in the community, in the school, wherever. You don't do that. You act like the bigger person. You wish them well, and you don't wear your emotions on your sleeve. You don't cry around the school, and you certainly don't bad talk anybody, even if you're thinking it and feeling it. Keep it close to the vest. You can come home and vent. But, and I explained, you do that, you're going to get a reputation. People are not going to forget what you did. You might have support while you're doing it, but it'll be remembered later that, when this went down, that's how he or she reacted. And it can follow you. I mean, we all know that, right? Reputations in school, they can follow you in your town for the next decades and decades. Granted, a lot of people move out of town. It's a very transient society we live in. But for those that don't, or when they come back, old memories die hard. And it's particularly true with, bad behaviors. As they say, you can only make what do they say? You have one chance to make a first impression, and reputations are very hard to get rid of once you get them. The bad ones in particular. I'd say definitely the bad ones. Number 22, judgment of a previous conviction, evidence of a final judgment of conviction if, and there's a whole slew, including the judgment was entered after a trial or guilty plea, but not a nolo contendere plea. B, the conviction was for a crime punishable by death or by imprisonment for more than a year. The evidence is admitted to prove any fact essential to the judgment. And D, when offered by the prosecutor in a criminal case for a purpose other than impeachment. And when they say impeachment, they mean impeaching someone's credibility, not impeaching them out of office. The judgment was against the defendant. So D again, I'm just going to say it again. When offered by the prosecutor in a criminal case for a purpose other than impeachment, the judgment was against the defendant. The pendency of an appeal may be shown, but does not affect admissibility. Okay, so judgments when you're previously convicted are generally that fact that you were previously convicted, that judgment convicting you is an exception to the hearsay rule. It can come in. Judgments involving personal, family, or general history or a boundary. So that would be legal matters, again, revolving family or land ownership, that kind of thing. And then there's 24 that just says other exceptions, and then they transfer you over to Rule 807. So I won't go into that. But anyway, so those are exceptions to the hearsay rule, but you have to first find out, is it hearsay? Is an out-of-court statement brought in to prove the truth of the statement within? If that's what it's in for, it is hearsay. And then you have to see if there's an exception to the hearsay rule with it. Often there's not. Like I said, a person can't just come in and say, Johnny told me that she slept with so-and-so, that might not be able to come in unless, now here's a twist on that. This is always like in the very sordid like cases we see or hear about occasionally. If there was a rumor going about town that Johnny cheated on Mary, Johnny's now dead. Mary is accused of the murder. Whether or not he was cheating on her, as stated in that statement that, Johnny said that, Wayne told me that Johnny was cheating on Mary. So Wayne said Johnny was cheating. Wayne's not there to testify that he said that and what he meant by it. Is that hearsay? Yes. However, it might not be hearsay if you're bringing it in not to prove that Johnny really was having an affair, but to prove that it was actually a rumor in town. It had been stated, Mary had heard it, and now Mary has motive. Even if that statement is completely false, it doesn't matter the truthfulness or the falseness of the statement, just the mere fact that it was made and Mary heard it. Now it's not hearsay, the purpose for bringing it in. And that one is used a lot. All right, hearsay, it's super fun, guys. I know there's probably a million questions on that, and I know we go over this a lot when we speak to it a lot when we're evaluating, the things before us, and we're giving our little part about, whether this evidence could feasibly be used in whatever particular subject matter we're dealing with at the time, which is always very exciting to me, guys. I really enjoy it. It gets a little in the weeds. So we just went over a quick little review here. So you have the basics of hearsay, why it's not allowed, and how you try to get around it if you're the one trying to get something in, and how you're going to fight it and claim it's hearsay if you don't want it in. So anyway, if you have any like specifics you want to go over, you want to flesh out, you want to analyze, I'm here for that, as you know. And yeah, do reach out. It was a pleasure, guys. Thanks for inviting me again, and I will talk to you next time. Bye, Quinn. Thanks.